be a first-degree misdemeanor in California. Obviously, the biggies like murder and rape and robbery are generally the same level of offense. But when you get down to third-degree felonies or first-degree misdemeanors, there is some difference from state to state.
All crimes are defined by either federal, state, or statute according to both action and intent. These are known as the elements of the crime.
In driving under the influence, DUIs, there are a couple of elements. That the individual was driving, number one, the state would have to prove that, and that the individual was driving with a breath alcohol level of over a certain limit, depending on the state you're coming. They are the different stages or elements that make up the crime as a whole, and each one has to be proven by the state beyond a reasonable doubt before the individual can be convicted.
In legal terms, you would say law would have an actus reus. That's a physical element. For example, if you pull the trigger of a gun, that is an act, that's a physical act of that particular crime. Along with the actus reus, or the physical element of crime, is the mental element, which we call the mens rea. And this sometimes can be a complex term because it encompasses a lot of different things. But basically, it's the criminal intent, and there are different degrees of criminal intent.
For example, in homicide cases, someone will say, yes, this person is dead. Yes, my client did it, but he had no intent because it was self-defense. The other guy had a gun or a knife, my guy had a gun. So the real issues generally come down to that Latin mens rea, that mental state, on whether or not, in most cases, the person intended to commit a crime.
So we only have a crime, and the elements merge together. That is, you have the mental intent and the physical intent merging together in concurrence, causing a result that is criminal in nature.
It's actually not as complicated as it sounds, because, for the most part, the elements of crimes are spelled out pretty clearly. So either you did or you didn't do it.
Crimes may be against a person or against a property. Crimes against a person include kidnapping and assault. The most serious crime against a person is murder. The U.S. Criminal Code separates the crime of murder into two different categories, first degree and second degree.
The difference between first-degree murder and second-degree murder is primarily that first-degree murder is committed with premeditation. That is, a time to stop and reflect and think about what you are doing. And second-degree murder does not require the state to prove a premeditated intent to kill.
Premeditation means that a person acts consciously and deliberately before committing the murder. They have enough time to reflect upon it so that we can say, although it's not a fixed point of time, it can be a matter of a few seconds, that they have deliberately taken another life after conscious reflection.
Murder without malice or anger is manslaughter, and it can be either voluntary or involuntary.
Manslaughter cases generally deal with an act which shows a willful wanton disregard for the safety of others around you.
For instance, shooting a gun up in the air where there's a crowd gathered is a negligent act, and if you cause a death by doing that, that would be a manslaughter.
There are different types of manslaughter. For example, we might have reckless driving that results in manslaughter. We may have drunk driving, that's a form of manslaughter. So manslaughter encompasses many different categories.
Now, battery, assault, and aggravated assault may sound alike, but each are really a different kind of crime against a person.
A battery is a crime which involves a touching or striking of another individual against their will. That is different from an assault, which doesn't require a touching or striking. An assault is a threat to another individual by either a word or an act which causes fear in that person, but does not require that person be touched or struck. Aggravated assault or aggravated battery is an assault or battery with an additional enhancing factor, either that a deadly weapon or a weapon be used, like a gun or a knife, or that it be committed on a person that's been deemed to be a more vulnerable victim, for instance, an individual over 65 years of age.
Property crimes commonly include offenses like arson, vandalism, and burglary.
Auto theft, breaking and entering into a home, stealing somebody's bicycle or snatching somebody's purse. Those are crimes against property, which are still crimes and are still serious, but they do not get the severity level that crimes against a person gets.
Burglary, for example, is someone enters a structure, a dwelling, or a conveyance, which is a vehicle of any kind, stealthily, and once they enter that structure, they intend to commit a crime by taking items that don't belong to them to use for their own benefit. A robbery, on the other hand, is when you take property from an individual by use of force, and that's the big difference there.
Another difference is that burglary is a property crime, while robbery is a crime against a person. And so from property crimes to crimes against a person, from the elements of a crime to the thousands of statutes which define them. The criminal justice system is set in motion by one simple act, a crime, a violation of the law. Once a crime has been committed, it's up to the police to investigate it. And from the moment they become involved, through the investigation and beyond, police officers must follow strict procedures and guidelines so that the rights of victims and suspects are equally observed.
There's a procedure and a process that you have to follow. Failing to do that could result in a case being thrown out of court, a defendant being set free. Could be the situation where you could be civilly sued and nothing's been gained. That individual is still out and about committing the crimes or the acts that we originally addressed them about. And you're in trouble. Your career, your department's reputation, and their credibility. So you've got to weigh all of those things. And first and foremost, you've got to ensure that everyone's constitutional rights are adhered to, regardless of the circumstances.
A police investigation usually includes a gathering of physical evidence, such as illegal drugs or firearms, as well as statements from victims and witnesses.
What time did you leave for work this morning?
That's what they got.
Okay. And what time did you come back home?
When you investigate a crime, you want to talk to anyone that has information related to that crime. That may be the person that telephoned the information in. It may be witnesses that you locate while you're at the scene of that crime. That's the investigative side of it. You want to gather as much information pertaining to that crime so you can conduct a thorough investigation. It may be collecting physical evidence that's left at the scene of that crime. May it be a weapon that was used, blood, anything of that nature. It could be clothing that was left behind. So you want to gather all of that as part of your investigation into the crime.
Police officers may also ask questions of people they consider suspects, and often long before they're ever under arrest.
They may question an individual at the scene of that crime. They could go to that individual's house and question them. They could go to their job equipment, and they can question them downtown in an interview room.
Not arrested, you take it downtown.
Do real-life police officers act like the ones on television? Do they intimidate a suspect until he breaks down and confesses? What actually happens during police questioning?
Mr. Smith, the reason we brought you down here, first of all, you're not under arrest. And the reason we brought you down here is we feel that you might have some information regarding the burglaries that occurred on the south side.
You'll see on television programs where a person will be in an interview room with a detective or detectives, and that individual is being physically abused. No, that's not an accurate depiction as to what takes place. In no way, shape, fashion, or form are we allowed to abuse that individual in any way, regardless of the crime or the circumstances.
They are not allowed to use any types of threats or coercion or, of course, brutality during any types of interviews. They're not allowed to make any promises of favorable benefit or favorable reward or better treatment from the prosecution's office in order to elicit or get some information from the suspect. And if it's been deemed that they have done any of those things, then any of the statements or admissions made by the suspect would be suppressed, would not be allowed to be used in court.
While physical abuse and psychological pressure are strictly prohibited, the police do have some leeway when conducting an interrogation. For example, they can lie to a suspect.
What would you say if I told you that Fred pawned the stereo equipment belonging to the neighbor?
They don't have to tell the individual that they're a suspect. They can even, in the course of health, use deception and tell them, for instance, we have this information, we've been told X, Y, and Z, how do you respond to that? They can use deception in interviewing potential suspects.
Now, if the suspect is a juvenile, a person under the legal age of majority, either 16 or 18, the police should make a reasonable effort to have the child's parents present for questioning, although the law does not require it.
If, for instance, a police officer interviews a child and never makes contact with that parent, and the child says, I said I wanted to have my parents present, that can have serious consequences. For instance, if a child confesses to committing a crime and the child was held, say, for 4 hours by the police, and no one made an effort to make contact with those parents, that confession could be suppressed by the courts. So that could be evidence that's lost because efforts weren't made to make contact with the family.
So the police may ask questions to gain information, leads on other suspects, or even a confession. But you don't have to answer a police officer's questions. Everyone, no matter who they are or what they've done, has a right to silence, and it's guaranteed by the Fifth Amendment to the Constitution.
You do not have to talk to the police. Outside of giving the police basic information about your name and address, you have absolute rights under the United States Constitution to refuse to talk to the police. Under the Fifth Amendment, you have an absolute right to remain silent, and you do not have to discuss your case or any circumstances surrounding it with the police. And that's called the privilege against self-incrimination.
So when should you talk, and when should you stay quiet? If you're the focus of a criminal investigation, most lawyers say you should never talk to police without an attorney present, even if you're innocent. Now, if the police have a reasonable suspicion that you're involved in a crime, whether you match a suspect's description or your behavior appears suspicious,
the guy sitting on the steps around the corner from me wearing a black t-shirt, black pants, just made a sale to the black BMW.
and if it looks like you're carrying a concealed weapon, they can pat you down for their own protection and yours.
You got anything on you, dope, guns, bombs, or any of that stuff? Okay. Is that okay to pat you down?
This rule is known as stop and frisk. And sometimes what begins as a simple pat down can lead to an arrest.
Just because an individual is walking down the street, they may look weird, they may be dressed weird, doesn't give a police officer a right to stop that individual. They have to suspect and they have to have information that would lead them to believe that that individual may have committed a crime or may be in the process of committing a crime. You can't stop an individual just because they look a certain way.
I would think there are more occasions for that to happen with juveniles than with adults, simply because juveniles, for instance, if they're not in school, they're supposed to be in school during school hours. If a police officer sees a child and suspects that the child is truant, then the police officer can make contact with the child to find out whether he or she is in school. And for instance, if the child smells of marijuana, once the police makes contact, the smell of marijuana gives the police officer justification to search the child.
Now, what if the police want to search inside your house for evidence? Well, they need a search warrant for that, thanks to the Fourth Amendment to the Constitution, which prohibits against unreasonable searches and seizures. That means the police need a warrant to search your house or even your car or business.
The reason you would want to get a search warrant is to obtain evidence of a crime. Evidence that may be concealed in a vehicle, it may be concealed in a residence or some other type of structure. And you do your investigation, you gather information that would lead you to believe that the evidence you're looking for is in that specific location.
Different jurisdictions handle search warrants differently. Throughout the country, some prosecutors' offices get involved in assisting the police in obtaining search warrants. In others, the police go straight to the judges and get the judges' signatures in obtaining these search warrants. But basically, when a prosecutor assists a police officer, we make sure that the police officers have probable cause to believe that evidence is located wherever it is that they want to search, whether it's a house or a car or a business. We then present the search warrant to the judge. The police officer has to swear to its accuracy and swear to the facts contained in the search warrant and takes an oath in front of the judge, and together they sign the search warrant, at which point the police officers then go and serve the search warrant on the defendant and his home and his business and his car.
But even armed with a search warrant, the police can't just break down your door. The knock and announce rule requires that officers make their presence known and state the purpose of their arrival. And the only exception to this rule is what's called exigent circumstances, circumstances that demand immediate action, like a drug raid. And because they're mobile, time may also be a factor with car searches. So if you're stopped for a traffic violation, the police may conduct a search of your car without a warrant, but only if they have probable cause, which is a good faith belief they'll find something concealed somewhere, like drugs or firearms.
There it is.
And only if they're able to articulate that probable cause in their police report. But what about your trash? Well, according to the United States Supreme Court, your garbage is fair game because it's considered abandoned property, not private property. You see, the job of the police is to find out who committed the crime they're investigating. So they'll do whatever they have to, even if it means looking through someone's garbage. But at the same time, the police must always follow the rules of law and procedure.
Both the police and the prosecution's office want those rules to be adhered to so that the evidence can be used in court, because that's the only good it's going to do us if we can use it in court in proving that a crime has been committed.
After the police have conducted their investigation and drawn some conclusions, the person most likely to have committed the crime is usually taken into custody and arrested. Probable cause. That's what a police officer needs to arrest someone. And probable cause is when the police have a reasonable belief that the person they want to arrest committed a crime.
It would severely damage my career to falsely accuse or arrest someone and take their freedom away just because I can't do it. And the Constitution doesn't allow me to do that. If an officer, God forbid, decided and they wanted to go out and do that, their career in law enforcement is pretty much going to be over. And in certain circumstances, they may end up in jail themselves.
The only place the police can't arrest someone is in that person's home, unless the officers have an arrest warrant signed by a judge.
The laws regarding protecting individuals who are in their home come from the Constitution, come from the courts, and come from the case law as we know it. The police are not allowed to go into someone's home to make an arrest unless they have an arrest warrant. And typically what you'll see is police going to a home, knocking on the door, announcing themselves, asking the individual to step outside, at which point they conduct an arrest.
But just as it is with a search warrant, the exception here is exigent circumstances.
If the police, for instance, arrive at a home that they're going to search or where they're going to arrest somebody and there is an injured victim inside who's perhaps dying, or the defendant has a gun to an individual's head, they don't have to stand at the door and knock and announce the presence there. They can violate that rule basically and go inside the house to try to save this victim or save the individuals because the circumstances require that.
Resisting arrest simply by pulling away is a misdemeanor, but pushing or shoving an officer or even swatting at his hands becomes assault, and that's a felony. One of our most well-known constitutional protections is the right to receive the Miranda warning, a right which comes from the Fifth Amendment and applies to both adults and juveniles. To be given the Miranda warning is to be told that you have the right to remain silent, that anything you say can be used as evidence, that you have the right to an attorney, and that if you can't afford an attorney, the state will appoint one for you.
The police are required to read a Miranda warning to an individual who is in custody. And in custody and under arrest are not always the same thing.
But when you have an individual in custody, it doesn't mean they're under arrest. It just means you have them detained. When you arrest a person, that means they have been detained, they are going to jail, and they are going to be booked into the jail.
And being booked is basically having the paperwork drafted up that states all your biographical information, getting fingerprinted, having your mug shot taken, your photograph taken.
Fingerprints and photographs are just one kind of evidence the police gather during the booking process. They may also ask for a blood sample or even strands of hair, both for DNA testing. This evidence is then used to match evidence left at the crime scene. And the police may even put you or your photo in a lineup to see if you can be identified.
In the lineups that are conducted by the police, suspects have the right to have an attorney present, an attorney to help stage the lineup so that it's fair and that it's not suggestive that you may have a lineup, for example, with 5 people or people of color and then 1 Caucasian, and the suspect is Caucasian. That would be suggestive. So the lineup has to be fair, and to ensure that it's fair, a lawyer should be present.
There's no procedure once a child has been arrested to appear in a lineup. But prior to being arrested, the police officers often do show-ups with the children. They take them back to the scene of the crime and ask the victim whether or not they can identify the child as being the person that committed the act that they're accused of.
And so, being formally charged with a crime begins when the police make an arrest. At that time, a suspect may be released with a citation or on a promise to appear in court, or the suspect may even be sent to jail.
Everyone who's arrested doesn't necessarily go to jail. It will depend on that individual's prior criminal history. If they don't have any prior criminal history, typically they will be charged or cited, given a notice to appear, and they don't have to be booked into jail. What they'll do is simply appear in court on a given court date.
When a juvenile is arrested for a misdemeanor, the parents are called, and the parents can come pick the child up from the detention center. The parents are given a notice to appear, the same that adults get sometimes, and they have the child's next court date on it. If a juvenile is arrested for a felony or a violent misdemeanor, such as domestic battery, that juvenile can be detained, which is held in the juvenile detention facility for a period of time while they're awaiting the arraignment on their official charges.
In the criminal justice system, the Constitution provides many different safeguards, always making sure that the accused are treated fairly and without bias.
I think one of the strongest points of the American justice system is that there are safeguards in our Constitution and in the laws to protect not only our individual rights, but also the rights of the community as a whole, to make sure we are all safe in our homes, in our businesses, and in the pursuit of our happiness.
From federal statutes to state statutes, search warrants to arrest warrants to Miranda rights, the system carefully balances the rights of the accused with the rights of the victim, as well as the safety of individual citizens.